Ms. Ellmers?
Thank you, Mr. Chairman. I have a couple of questions, and thank you for coming today. And actually, I would like the for both of you to weigh in on these. And I know that you have basically stated that you're not necessarily discussing some of the actual rule positions, basically, as it is. But I am curious again, and I know this question's been asked already. I'm just curious about the timeline. What, you know, I know you are still receiving comments now?
Congresswoman, no, the comment period's over.
It's okay, but and the comments are being reviewed.
Absolutely. Congresswoman, the question that we receive all the time is, when is this process going to end?
Mm-hmm.
When are we going to have a final product? And I appreciate that very, very much, but and I was pleasantly surprised, or maybe not pleasantly surprised, when I came to work at USDA. I didn't realize what everyone had to go through to go through the rulemaking process. This was really new to me,
Mm-hmm.
and it was a surprise to me. But
And I think you may have, this question may have already been posed, I'm not sure, but how many people are working on this? How many USDA staff are reviewing the comments and coming up with kind of a...
Congresswoman, I can't tell you exactly how many, but we have contracted outside the agency for assistance. But I'm not sure if you were here when a similar question was asked. That, you know, we received these 60,000 plus comments.
Mm-hmm.
Okay, and then we summarized them, and we put them in a category based on how they address specific provisions of the proposed rule. And then now we're looking at alternatives, at options that have been proposed, and it just takes a long time.
Also, and there again, that gives me as much information as I do want to ask about the economic analysis of the proposed rule. Will that information be released? My understanding is you have done an economic analysis.
Congresswoman, in the proposed rule, there was a economic analysis, cost-benefit analysis, and we have received quite a few comments on the costs.
Mm-hmm.
And as I mentioned earlier, our chief economist is leading a team, is preparing a very thorough cost-benefit analysis that will be in the final product. Right now, it's really too early to prejudge what the final product is going to look like. And you know, I want to emphasize to you, Congresswoman, and to the committee that based on the comments, no option is going to be ignored. We're going to look at any possible option. And it's really too early right now in the process to give you a timeline and to tell you if we're going to, you know, what we're going to do with the final product, if we're going to have it.
Will you allow for public comments on that? I mean, we have submitted a letter. Many of my colleagues, myself and 146 other members,
Congressman,
asked for this.
Absolutely. I'm real familiar with the letter.
Okay.
But on the comments, it's too early now to determine if we're going to have another comment period, because we don't really know what the final product is going to look like.
Okay. Have you spoken to stakeholders about how the rule may impact their businesses? And if so, have you spoken to those in North Carolina?
Congressman, we haven't since you know, the comment period opened, and now that we're after the comment period trying to draft the final product, we can't talk directly to stakeholders to tell them about what we might propose, what we might not propose. Mm-hmm. However, I have spoken a lot with stakeholders. As part of my job, I've been keynote speaker at sheep industry groups, cattle growers, and of course the question always comes up on the proposed rule. And I can't get into specifics with him, but one thing that I have told him, 'cause one thing that comes up all the time is premiums to producers. And that's one thing that I can say, and I always tell them that the Secretary and I strongly support value added, we strongly support marketing arrangements, we strongly support premiums being paid to producers.
I have one more question, and I asked the chairman if I know I'm about ready to run out of time here, if that would be all right. And I'll direct this to Mr. Christian. It is a specific question. In the proposed rule, GIPSA is attempting to overturn numerous judicial decisions by providing that this is a quote, finding that the challenged act or practice adversely affects or is likely to adversely affect competition is not necessary in all cases, end quote. Basically, the way that I interpret that is that the plaintiff would now not necessarily have to show actual harm when challenging a packer activity. Is this correct? Is this basically the interpretation of that?
That is somewhat correct. The department's longstanding position is that to prove a violation of the two sections of the Packers and Stockyards Act that apply to packers and swine contractors, that would be 202A and 202B, the unfair practice section and the unreasonable preference section, that in some cases you do not need to show competitive harm to prove a violation. An example might be if someone is fraudulently weighing your livestock at the packing plant. You as an individual packer, as an individual producer, when GIPSA brings that case against the packer for weighing your livestock incorrectly, we bring that administratively for livestock and can assess a penalty, and we don't have to show competitive injury. So that's the department's longstanding position. There are some cases where you do have to show competitive injury, some cases of unfair practices, and that may be a situation where a packer is working also as a dealer, and there's a lack of competition in that practice. So that's the longstanding position, and then the intent of this rule was to clarify that longstanding position.
Thank you. I yield back.